This is a section on removal and obliteration, but this is in the 1990 Act, the original Act, not the 2007 statutory instruments which add to it. This is before I think this is before they had the classes, the different class A, B, C and D. But it still actually created the term advertisement. It says here, the first part here, all right, shall be deemed to display an advertisement for the purposes of that subscription if he's the occupier. Or so even if I put a political advertisement on someone's property, the person whose property is deemed to be displaying the advertisement, or if it displays goods that they are selling. Well, if I put a petition on someone's building, it's not displaying their goods. Or other concerns. If somebody gives publicly to his goods, trade, business, or other concerns. Well, if they support, what happens if they supported your petition? You know, that would be a concern, wouldn't it? They may support it, but it's still deemed to be an advertisement if it is on the land. Well, it's deemed to be displayed by that person who owns the land. A person shall not be guilty of an offence under subsection 3 by reason only of his being the owner of the property or his gazettery. So you can't just, if I put a notice on someone's land, just because it's on their land, or just because it might be advertising their goods or concerns, he proves it was displayed without his knowledge or consent. There's something in that for if people. The thing is, it's this consent again in this act, and then when they bring the new statutory instruments to add on to it, if you're exempt from both of the consent sections, then clearly it's actually that act is this act. Then this 1990 Act sets out the definitions for advertisement, meaning that it includes like representations and so forth. The statutory instruments is enacted under the powers of this Act to add additional legislature to it, so that all of the terms in this Act are directly applicable to the statutory instruments, because it's one thing. They're both one thing. So again, on private property, it's about consent. But if if the only two sections for consent are deemed consent and express consent, then you're exempt from both of them, surely. But why? Well, because if it's political and you're using that enactment where you're not liable to be prosecuted, you don't need consent, do you? Because they can't. Well, they can't really. They can't really stop you from doing it legally. That's why. Power to remove or obliterate. So this is when it comes to the police and the council, the authorities. Subject to subsection 2 and 3, local planning authority may remove or obliterate any placard or poster. Well, note that if they obliterate it, and if any damage is caused from obliterating it, then surely they've caused the damage, not the person who put it up. Because merely putting something up doesn't necessarily damage something. But if you obliterate it, you're actually damaging the poster itself or the advertisement. So actually damaging the advert. the fixtures and fittings part is regarded as necessary for the advertisement to be placed, and if you've got consent, that comes part and parcel with it. Which is displayed in the area, which in their opinion is displayed in contravention of a regulation made under Section 220. Subsection 1 does not authorise the removal or obliteration of a placard or poster displayed within a building to which there is no public right of access. So basically, if there's a public right of access, it's something to do with the council can engage, because it's, council's public right of access. If there's no public right of access, then it's considered private. The placard identifies a person who displayed it or caused it to be displayed. The local planning authority shall not exercise any power conferred by Section 1 unless they have first given him notice in writing that, in their opinion, is displayed in contravention of the regulations made under Section 220, and that they intend to remove or obliterate it in the expiry of the period in the notice. He says placard or poster, where a placard or poster identifies a person, or where it identifies the person. Any placard or poster, but does it say advertisement though? It says it's referring to placard or poster, but does it actually mean advertisements? Power to remove or obliterate placards and posters. But what about advertisements? To display an advertisement for the purposes of that section, if it is an advertisement. I think the placards and posters can be advertisements if they are advertising something. If the placards and posters are advertising something, then surely they are advertisements. So this is the thing, with the Criminal Damage Act, right? This is the problem, right? If there's something being done or put somewhere, and this is a key thing, and the authorities, the police or the council don't like it, right? But it's, if they concur that it's an advertisement and they know it is, they can't do anything until they've issued a notice to the person first to remove it, which, and then I would suggest that even would, any of the classes then, I would suggest that because this is still in force and this is supposed to work with all those classes, then they've got to inform people from the classes as well, which includes Class C, the paint as well. You see, if they play stupid, if they say, if they refuse to recognise, acknowledge, or accept that this is an advertisement, right? Then they can, prosecute for criminal damage. Now, the thing with prosecuting for criminal damage is you don't have to send someone a notice to remove it or anything like that. The police will just take it off. But the thing is, if the police take it off, then, the police causing damage. And in fact, there might be damage in the advert. They're trying to have poetic license to define and describe something so they can use a completely different law and act as if they've got a poetic license, but they don't, because an advert's an advert, right? The Criminal Damage Act is not made for adverts, because if it was, then, in the Criminal Damage Act, there's nothing to say remove an advert. So you got, so the Criminal Damage Act is for, like, someone putting the fist through a glass window or kicking a car door or, walking down the road with a key and scratching loads of cars. That type of things, bumps, scrapes, smashes, stuff like that. Not something that is defined and identified as a advertisement, a representation, a placard, or whatever, no matter how it is attached or fastened, because that comes with whether you get consent or not, because things have to be fastened, and even if those things would be categorized as damage, well, if you've got consent, then you're always going to fasten something with something if you've got consent. So it's consent to. Consent to place the advert is consent to attach it with whatever it needs attaching with, whether it's, paste, poster paste, screws, nails, whatever, or spray paint is attached by itself on the merit of it being sprayed on and drying or painted on and drying. This is a thing. Those things are designed for a function. You go to a DIY store to buy things that they're made to attach things. This is the thing. What is sellotape? It's made to stick things with. What are nails? They're made to attach things with, right? In the Criminal Damage Act, those things have got a purpose, a reason. They're meant to be used. Now, either you've got permission to use them or you haven't, right? And permission to use them is permission for them to, do whatever they're doing to the thing that you're attaching the surface to, including the surface. With the Criminal Damage Act, it's different because, firstly, it's not an advert, and anything that is, it's not purposeful design or intent. A car door is not designed to be dinted. If you have a crash and accident, it crumples, but it's, you're supposed to avoid accidents. Nails aren't to be avoided. They're to be nailed in. A window's not purposefully designed to be, punched through. Someone's sweater is not designed to be, ripped on purpose or, put a cigarette burn on it. This is the thing. The Criminal Damage Act it's not subsequential damage from things like, hammering a nail in to fasten an advertising board up, because the advertisement is, it's designed to be nailed up if it's that type of advert. Either you've got consent or you haven't. You see, the Criminal Damage Act doesn't even discuss any of these things. They're not even discussing them. I mean, at least when you're on the right act like this is what you're discussing. Is there consent or not? But if you notice, they're not even touching it because they don't want to, because they know you've got the classes and they know that they've got the political class and they know you're using enactment, and then they have to start talking about it. If they're just like, someone's just damaged something, they're not even exploring those questions. It's all about, this person has caused damage, but they're trying to plead, why did they spray this on here, or because of the environment, or whatever, was that reasonable response to the environmental catastrophe, or was this a, what's proportionate response? What's that got to do with anything? At what point does that Criminal Damage Act... you're not even first, they're not even recognising it as an advert, and they're not even bringing, classes or whatever into it. It's that they're not even on the right page. They're not even in the right act. And I think the police know that, and the problem is that they just don't want to acknowledge the act, because they've got procedures they've got to do, and they can't do what they want. They don't have poetic license when something is explicitly, it's enacted to be used. This act for these matters. You see, I got prosecuted for criminal damage, and they obliterated all mine, and I never got a notice through from them. I'd even actually had the council I'd actually got permission from one council, but the police didn't like them. And I got prosecuted for criminal damage, and they didn't even they didn't even mention this Town and Country Planning Act either. They just want this is damage, that's damage. It's actually not. It's considered as an advertisement. Placard. Well, the thing is, if you're doing a petition to the government, it identifies what the case is, the petition case. If you're doing it with Parliament, you get a number. You get like a petition number, which is like a case number. So it definitely identifies who and what it concerns. There's something about the passage of time. I hope I covered that in the other videos. I really want to cover this passage of time thing because I need to find out which part it's in. It's only like a short one. It's like 2 sentences, and it talks about conditions of surfaces and things like that can change over time without even like something might just peel off by itself or whatever, or and the Criminal Damage Act doesn't cover any of those subjects, and that's critically important when you're putting notices up, sticking things or surfaces, because they might just fade. If you do like a photocopy of something and fasten it up, then in the sun outside, the toner from the photocopying machine might have completely faded off in 3 or 4 months. So there's nothing there. So there's not even any writing on it. You just might be left with a blank sheet of paper stuck to something, and then that might even if it's paper, is biodegradable anyway, or could peel off with the wind and rain, and then it comes off itself. All these things are not even mentioned in the Criminal Damage Act, which is why that Criminal Damage Act is not designed for notices and advertisements and messages, because they are made to put up and to put up, and whether you've got permission or not, then even if you haven't, when you're looking at it, all these factors have to be discussed. If you're using the Criminal Damage Act, you don't even discuss, the fact that something could just fade off itself, or if someone writes marker pen on something, that might just, even come off with wear when people are, if it's like a bench, if it's like a metal bench that you sit on, after, people have been sitting on it for, 3 or 4 months, the paint might just end up coming off by itself or wear off. Even the bench itself needs repainting, even the bench itself needs repainting. So you've got this constant change in materials all the time, which if you find that sentence, it gives an acknowledgement to that and to be taken into consideration. With the Criminal Damage Act, there's nothing like that, nothing at all, because it's just a different set of factors. Notices are usually only for a certain period of time anyway.